So HJ Res 127 is accumulation of a 14-month investigation. I believe this is our fourth hearing on climate disclosure. Last year, the Subcommittee on Oversight and Investigations requested information from the Securities and Exchange Commission to help inform committee members about the SEC's authority to promulgate a rule on climate disclosure. Instead of cooperating with the committee's numerous requests, the Commission played games, flooding committee staff with tens of thousands of pages of unresponsive documents and very few answers, and ultimately moved forward on an even larger 886-page final rule. Some might recall that I received my own congratulations letter to the chairman as one of those documents of, quote, openness. Only in Washington does a rule increase by nearly 400 pages, and it's celebrated as, quote unquote, narrowed. So in the 2 years since the climate disclosure rule was first proposed, we have witnessed an unprecedented assault on our capital markets. Let us make no mistake, the Commission finalized this rule despite no clear authorization from Congress. In a rush to appease the radical left, Chair Gensler finalized a rule that will increase the cost of being a publicly traded company by around 21%. And how did the chair respond to concerns surrounding his rule? He doubled down. Chair Gensler ignored the warning from the Supreme Court, which ruled in West Virginia versus EPA that the EPA exceeded its statutory authority, relying on ambiguity as constituting an implicit delegation from Congress. Chair Gensler then ignored the warning from the Fifth Circuit Federal Court of Appeals, which ruled against a separate SEC finalized rule about share repurchase disclosure. In that opinion, the court rightfully held that the, quote, the SEC acted arbitrarily and capriciously in violation of the Administrative Procedures Act when it failed to respond to petitioners' comments and failed to conduct proper cost-benefit analysis, close quote. And finally, Chair Gensler ignored his own Inspector General, who concluded that the SEC faced serious management and performance challenges, raising significant concerns that the agency was attempting to enact too many rules too quickly, in essence, flooding the zone. The fast-paced rulemaking over the last 2 years has raised serious questions about how important Gary Gensler views the internal economic analysis conducted by his agency. Additionally, the SEC's climate disclosure rule blatantly undermines the Commission's existing materiality standard. Under the principles-based materiality standard, a company must disclose information to prospective investors and shareholders so that they can make informed investment decisions. The SEC should not statutorily redefine the materiality standard to prescribe climate-related disclosures for all public companies, even when a reasonable investor would not find such information important to their investment and voting decisions. And I know some of my colleagues will say everything is material because it's the climate. Well, that is not what the law says. So, in just 9 days after the SEC finalized the climate disclosure rule, judges of the Fifth U.S. Circuit Court of Appeals granted a temporary stay. Then, before the ink had even dried on the final rule, the SEC voluntarily delayed implementation of its own rule to allow the numerous court challenges to move forward. And let me conclude with this. Although Chair Gensler has repeatedly reminded the public that he is not in his words, climate regulator under his leadership, the SEC has strayed very far from its clear statutory mission. Investors should know that the SEC's overreach will significantly hurt our economy while serving as a boon for special interest groups and far-left activists. Unless he radically alters this approach to our capital markets, Chair Gensler's legacy will be that of an overzealous bureaucrat who was repeatedly reined in by the courts. I urge members to immediately provide disapproval of the rule submitted by the Securities and Exchange Commission relating to the enhancement and standardization of climate-related disclosure for investors, and I yield back the balance of my time.
I'd like to strike the last word.
For what purpose? The gentlelady is recognized for 5
I
minutes.
move to strike the last word.